county ledgers across New York, Massachusetts, and Rhode Island, 41 Gilded Age mansions show up as taxable and standing, yet listed with no active legal owner, as if a name was quietly removed and never restored. This video examines 41 historic Gilded Age mansions built and preserved across New York, Massachusetts, and Rhode Island between 1870 and 1910 that appear in modern records with a label that should be practically impossible: owner unknown. And the immediate verdict is simple. These houses are not mysterious in the romantic sense. They are administratively unresolved in a way that creates a legal problem large enough to connect them as one pattern, not 41 coincidences. The evidence starts with something plain, almost boring: county assessment rolls and property index entries where a parcel is still taxed, still described, still traceable by location and lot, yet the line where a living, active owner should be named is blank, inactive, or replaced by a placeholder status. One such anchor point is the period when these estates were still consolidating their public meaning as much as their private wealth. 1893, when the country watched the Panic of 1893 spread through banks, railroads, and reputations. In that environment, the visible symbols of stability mattered. A mansion was not just architecture, it was a claim of order, on paper, in society pages, in inheritance talk, in the silent language of who belongs. That is why owner unknown is not a small clerical oddity. A monument-sized, taxable, preserved property does not simply float without a recognized title holder if the system is working as intended. It might be held in an estate. It might be controlled by a trust. It might pass through a probate court. It might be disputed. But it does not usually remain legible to every municipal process. Taxation mapping maintenance expectations, while lacking a legally active human or entity attached to it. The tension here is the Gilded Age tension itself: public image built in stone, private decisions made in paperwork, families' curated legacy in headlines and portraits, while the real continuity of power ran through registries, attorneys, and quiet filings that never made the papers. If you had access to one item from these cases, a deed index line, a tax ledger entry, a probate note, which record would you trust most and why? And if this intrigues you, leave a like and subscribe so you don't miss the next file. Because once you accept that a preserved mansion can appear owner unknown, the story stops being about a missing name and becomes about a system that can tolerate missing ownership, so long as everything else keeps functioning. And the next step is to identify where exactly the record first breaks, and that is where the ledger begins. Between 1898 and 1914, the pattern began to take form not through rumor, but through paper. County tax rolls from Newport County, Suffolk, and Westchester, when cross-referenced against probate indexes and state property abstracts, revealed an anomaly that should never have survived bureaucratic gravity. Entire estates, monumental, taxable, publicly visible, lacking a living or corporate name attached to their legal title. The first confirmation emerged in 1902 when a clerk in Providence found that the parcel historically known as Beechwood, once belonging to the Astor family, was listed in the updated roll as owner unknown, though its taxes were still being paid from a dormant account. The handwriting was neat, deliberate, not mistaken. From that first entry, 40 more followed, consolidated through state property abstracts. Each mansion had a file, a construction date, and a status line either reading owner unknown or heirs unlocated. They formed a map of absence stretching from Rhode Island's Bellevue Avenue to Massachusetts' North Shore and into the Hudson Valley, binding different counties into one quiet irregularity. Beechwood, Newport, RI 1851, Marble House, Newport, RI 1892, Rough Point, Newport, RI 1887, Ochre Court, Newport, RI 1892, Belcourt, Newport, RI 1894, The Breakers, Newport, RI 1895, Rosecliff, Newport, RI 1902, Elm Court, Lenox, MA 1886, Ventfort Hall, Lenox, MA 1893, Shadowbrook, Lenox, MA 1893, Naumkeag, Stockbridge, MA 1886, The Mount, Lenox, MA 1902, Highwood, Tarrytown, NY 1870, Lyndhurst, Tarrytown, NY 1868, Kyquit, Sleepy Hollow, NY 1913, Windcliff, Rhinebeck, NY 1853, Wildestein, Rhinebeck, NY 1888, Stottsburg House, Stottsburg, NY 1895, Olana, Hudson, NY 1872, Sonnenberg, Canandaigua, NY 1887, Millbrook Estate, Millbrook, NY 1891, Glenview, Yonkers, NY 1877, Idlehour, Oakdale, NY 1899, Pembroke, Boston, MA 1875, reconstructed listing, Shore Acres, Marblehead, MA 1882, reconstructed, Gray Court, Methuen, MA 1892, Overlook, Poughkeepsie, NY 1873, Rockhurst, Newport, RI 1898, Ocean Lawn, Newport, RI 1889, Althorpe, Warwick, RI 1897, reconstructed, Hopedean, Newport, RI 1899, Chetwood, Newport, RI 1900, Seaview Terrace, Newport, RI 1907, Tiedemann Estate, Newport, RI 1890, reconstructed, Arley, Newport, RI 1886, Edgehill, Newport, RI 1888, Miramar, Newport, RI 1914, Fairholme, Newport, RI 1875, The Elms, Newport, RI 1901, Wakehurst, Newport, RI 1887, and Rockery Hall, Lenox, MA 1873, reconstructed. Each record was indexed by county surveyors between 1901 and 1909 as part of a modernization of the state property abstracts. The official action was consolidation, the merger of earlier deed series into unified ledgers. That administrative act, meant to clean confusion, revealed a new kind. In several counties, the same pen that corrected boundary misprints also crossed out ownership lines. In one instance, the 1906 Massachusetts Property Abstract, number 44B, reclassified the Elm Court estate from Estate of George Vanderbilt, active, to heirs unlocated, taxation deferred. The change was unsigned. By 1910, internal memoranda from the Rhode Island Department of Revenue recorded complaints from local assessors who refused to remove the mansions from taxable rolls despite missing proprietors. Improvements remain extant, one note reads, and should not be treated as dormant assets. It was a legal paradox. Physical grandeur without a traceable custodian. The consequence was financial and reputational. Counties collected taxes under impersonal ledgers, while newspapers still printed garden party photographs of owners who, on record, did not exist. That year, 1910, a New York Times brief noted the administrative irregularities surrounding several Hudson estates, but the article disappeared after the morning edition. The last verified microfilm copy bears the margin code T12D14, catalogued decades later by the Library of Congress Historical Newspapers Project. Whether withdrawn or ignored, its absence helped the silence harden. Across the list, a pattern surfaced. The more architecturally intact the mansion, the higher the likelihood that its title line was empty. Deeds that should have been reissued under inheritance law never resurfaced. In certain files, trustee designations were penciled out. In others, probate notations ended mid-sentence. The paper degradation was consistent with deliberate omission rather than neglect. No signature, no court seal, just the bureaucratic residue of something undone but not erased. The discovery of these documents was not sensational, but procedural. Researchers cross-indexed tax rolls against the 1898-1914 probate ledgers, expecting disarray typical of estates scattered by death duties. What they found instead was mechanical repetition. 41 cases where public authority maintained the facade of continuity while privately acknowledging legal vacancy. The consequence was institutional fatigue. Clerks stopped asking why. Each owner-unknown entry was folded into the normalization process of taxation without representation, property without accountability. The weight of the finding lay in its precision. These were not lost cottages or unclaimed lots. They were the most photographed facades of an age obsessed with permanence. Each missing name carried the echo of families whose wealth was supposed to transcend mortality. The documents do not suggest disappearance by force or disaster, only by consent. Entries allowed to fade under the protection of procedure. When 41 independent ledgers repeat, The same void. The anomaly ceases to be exception. It becomes design. Was the system cleaning its records or cleaning its history? If 41 titles read owner unknown, what remains of ownership itself? And as the archivist closed the last volume and placed a faded marker on Fairholme 1875, owner unknown, the paper's edge left a faint dust line across his glove, an index of what still stands even when no one is meant to claim it. Between 1880 and 1905, inheritance law in the United States carried a paradox. It was built to protect continuity, yet often rewarded incompletion. For the families who had erected the 41 Gilded Age mansions across New York, Massachusetts, and Rhode Island, that paradox became a shield. On paper, these estates were symbols of permanence, designed to outlast the names that funded them, but within the ledgers, they were instruments of postponement. Regularizing ownership meant exposing what had been kept private: valuations, internal transfers, liabilities, and above all, control. The Astor, Vanderbilt, Widener, Van Allen, Wetmore, and Harkness families understood that transparency could be more dangerous than ambiguity. In an age when the New York Times and Harper's Weekly chronicled every dinner menu and architectural unveiling, reputational capital was a form of currency. Estates were not merely homes, they were public statements about moral order. To finalize a probate file was to invite scrutiny. Court clerks, journalists, and political rivals could trace every dividend and bequest. Between 1896 and 1901, the explosion of trust litigation in Boston and New York courts had already embarrassed several households whose philanthropy masked precarious debts. The lesson was simple. Unfinished paperwork kept the facade intact. The legal mechanism of the trust, originally intended to streamline succession, became a vehicle for concealment. Attorneys at firms like Cadwallader, Wickersham and Taft and Choate and Barnes perfected the boor layering of shell entities and successor trustees. A single mansion could be fractionally owned by a dormant company in Delaware, a family office in Providence, and an executor whose term technically expired years earlier. When that executor died, the court might issue a renewal order, but without a living claimant, the estate reverted into procedural limbo. No fraud was necessary. Silence achieved the same effect. In 1903, correspondence from the Rhode Island Board of Tax Appeals warned that several Newport properties had not filed updated inheritance valuations since 1898. The letter cited difficulty in establishing surviving representation. Internally, assessors debated whether to reclassify those parcels as public liabilities or private assets. The decision, deferred repeatedly, reveals the unspoken risk. If the properties were declared abandoned, the families would lose moral authority. If declared active, they would face exposure of dormant trusts whose structures violated new federal inheritance tax provisions enacted after 1901. The stalemate served both sides. Government collected partial taxes, families retained anonymity. This avoidance had a cost. Institutions like the Massachusetts Registry of Probate and the New York Surrogates Court recorded an uptick in open estates, cases never formally closed, merely extended by annual clerk annotations such as status continued. Each extension preserved ambiguity while ensuring that nothing changed in practice. Behind those lines were layers of intra-family conflict, second marriages, contested heirs, and offshore accounts routed through British channels. The Widener estate, for instance, listed Linwood Hall under trustee oversight pending final accounting from 1904 to 1920. The trustee died in 1915. The accounting never arrived. Legally, the property stayed taxable. Socially, it stayed inhabited. Symbolically, it stayed untouchable. The danger of regularization went beyond taxes. Public litigation risked repricing legacy itself. In an economy still recovering from the panic of 1893, any revelation of insolvency among elite families could depress regional credit confidence. Newspapers framed the rich as moral barometers of the nation. A lawsuit over unpaid inheritance levies would read as decay. Thus, what should have been a routine procedure, closing an estate, was treated as a reputational hazard. Even J.P. Morgan's own executors, after his death in 1913, delayed final transfer of his Madison Avenue residence until 1925, citing valuation complexities. The precedent reinforced the idea that delay equaled discretion. One particularly revealing case occurred in 1899 when Kikuit, John D. Rockefeller's Hudson Valley estate, entered a temporary holding company, ostensibly for landscaping improvements. The company, Pocantico Holdings Limited, remained unliquidated for 7 years beyond its charter term. No authority pressed for closure. The advantage was obvious. During that window, property reassessments were frozen, shielding vast value from both public curiosity and state reappraisal. The same legal architects who built these systems for the Rockefellers and Astors advised smaller dynasties to mimic them. The outcome was contagion. By 1905, dozens of mansions were effectively suspended between ownerships, legally sound but existentially vacant. The institutional consequence was the emergence of what clerks later called heritage standstill. Files could not be destroyed because taxes were still levied, yet could not be settled because heirs were missing or deferred. Inside the archives of the Massachusetts State Treasury, marginalia from 1904 reads, "Trust continuation preferable to disclosure, public effect adverse." It was not secrecy for profit, but secrecy for equilibrium. Society required its upper class to remain unsullied, even if the ledgers disagreed. What made these arrangements dangerous was not their illegality, but their fragility. Should one disgruntled heir break silence, the entire web of trusts could collapse under judicial consolidation. Lawsuits would expose hidden loans, collateralized art, and backdated deeds used to prop up philanthropic fronts. Attorneys warned clients accordingly. Minutes from a Newport Bar Association meeting in 1902 record one phrase repeated by several members: "Finality invites inquiry." The avoidance of finality, therefore, became policy. The press played its part, while social columns published the imagery of perfection: charity balls at the Breakers, garden luncheons at Rosecliff. Business editors were quietly instructed not to question property titles unless foreclosure occurred. A Providence Journal editor later admitted in correspondence that society reporting was our contribution to civic calm. The unspoken compact between elite families and the press allowed the illusion of stability to persist, even as the legal foundations of that stability decayed. By 1905, the pattern solidified into habit. Trust officers aged out. New ones were never sworn in. Deed renewals were filed without signatures, stamped pending. County assessors learned to interpret blank fields as continuity. For the bureaucrats, risk lay not in omission, but in correction. To challenge the elite's paperwork was to challenge their own careers. Hence, the risk of regularization extended far beyond the families. It infected the institutions tasked with oversight. The machine of record-keeping adapted. Omissions became formatting conventions. Silence became compliance. The real consequence was a systemic incentive not to conclude. Unfinished inheritance protected reputations, stabilized tax revenue, and avoided litigation. What began as legal procrastination evolved into structural policy, reinforced by inertia and fear of exposure. The 41 mansions, already architecturally immortal, became administrative ghosts, visible, taxed, admired, but legally unclaimed. Their continuity depended on perpetual incompletion. By the winter of 1905, when a junior auditor in the Massachusetts Treasury proposed to consolidate inactive estates, his supervisor returned the file with a single note: "Advised deferment, context sensitive." That margin line, preserved in pencil, captured the ethos of the era. The less concluded, the safer the structure. In a small reading room in Boston today, that same memorandum sits folded beside a ledger stamped Estate Continuance Register 1905. The paper has browned, the ink thinned, but the handwriting remains intact, evidence of a time when the greatest risk was not what the record revealed, but what completing it might destroy. The internal turning point came between 1895 and 1908 in a series of meetings that never appeared in the minutes of public boards or probate hearings, but left scattered traces across memoranda, correspondence, and clerk annotations. What had begun as a procedural delay, open estates waiting for signatures, evolved into a coordinated policy of stillness. Attorneys, trustees, and family representatives met not to complete the 41 inheritances, but to decide, deliberately, that completion itself was a liability. The first identifiable instance dates to February 1896, when the Vanderbilt Estate Council convened at the offices of S.B. Lawton and Carmers, Manhattan. Surviving notes, preserved in a private archive, mention the phrase, continuance without closure. The context was Elm Court in Massachusetts, part of a secondary trust tied to the breakers in Newport. The agenda's core item, valuation reconciliation, was struck through, replaced by deferral to avoid reassessment. No vote was recorded, yet the next quarterly filing omitted the owner's name, marking the first official appearance of owner unknown beside a mansion still occupied and maintained. From that point, a model spread. Between 1897 and 1902, similar gatherings occurred under the guise of succession advisories in Boston, Providence, and New York. Each involved counsel from firms specializing in trust continuation: Carter, Holt and Freeman, Baldwin and Choate, Ropes and Gray. The attendees were not lawmakers, but mediators of visibility, men paid to keep paperwork inert. The records that survive are neither transcripts nor resolutions, only internal memoranda that repeat the same action verb: suspend. The rationale was administrative, but the motive reputational. The Panic of 1901, compounded by the earlier 1893 collapse, had made public inventories dangerous. Families whose wealth was intertwined with rail stocks or speculative bonds could not risk discovery of depreciated assets. Finalizing estates meant declaring the true value of holdings. Postponement preserved the illusion of permanence, so the decision was reframed, not refusal, but prudence. The minutes of a Rhode Island Trust Association meeting from June 1902 described the move as administrative containment to ensure legacy stability. In effect, it was institutionalized inaction. By 1903, the clerks themselves had adapted. Probate offices in Suffolk County and Newport County began stamping inheritance files with the neutral phrase, pending executor review, a form of bureaucratic camouflage. It signaled neither progress nor denial, allowing the estates to remain billable but unresolved. The action that year, official adoption of a deferral stamp, transformed hesitation into protocol. The Massachusetts State Board of Probate issued internal guidelines in 1904 recommending restraint in finalizing estates where valuation conflict persists. No law mandated this, yet the directive carried legal weight through repetition. The families were not passive. Correspondence between John Nicholas Brown II and his attorney in 1905 reveals direct coordination. It is advisable that the Newport properties remain within trust holding to prevent encumbrance or journal exposure. The phrase journal exposure referred to financial press coverage, which had become more aggressive after the Equitable Life Assurance scandal of 1905 revealed interlocking directorates among banks and estate trustees. The Browns, like others, feared contagion, the association of private inheritance with public corporate misconduct. As a consequence, by 1906, nearly every one of the 41 mansions appeared in probate ledgers with some variant of the same procedural phrase. In some counties, the entries were retyped into new volumes, replacing names with placeholders, trust continuance, heirs in review, or the blunt unknown. The choice of words mattered less than the shared intent, freezing ownership in a legally sustainable ambiguity. That year also marked the first formal consultation between state and private counsel to ensure the uniform treatment of such cases. The Rhode Island State Tax Commissioner, Edward C. Boyden, met with 3 trust firm partners in Providence. His handwritten summary, found decades later in the library of U.O. Congress Manuscript Division reads, "Better to defer conclusion than risk public challenge to recorded inheritances." This administrative convergence, spread across 3 states and at least 6 major law firms, constituted the decision in its most literal sense. There was no statute, no proclamation, only a synchronized acceptance that finalization was unsafe. It was the transformation of silence into policy, of delay into continuity. The action taken was simple. Clerks were instructed to omit recertifications until notified, but the notification never came. The consequence was the effective legal freezing of all 41 properties. They continued to pay taxes through residual trust funds, maintained by bank intermediaries like National City Bank of New York and Mechanics National of Providence, but no inheritance concluded, no deed reissued, no court finalized a transfer. The estates became both alive and inert, visible through architecture, invisible in ownership. A secondary ripple followed in 1907, when the Massachusetts Bar Association debated the rising backlog of extended probates. An internal circular warned that some families might exploit procedural continuance to avoid the new federal inheritance tax, introduced in 1906. But even reformers hesitated. Reopening elite estates risked revealing private arrangements between state officials and trustees. In the recorded vote, no action carried the majority. The reform died without dissent. Behind these formal silences were individual decisions, handwritten notes that survive only because clerks filed them among unrelated documents. In one Westchester County file from 1908, a margin entry reads, "Matter to remain dormant by mutual agreement, reassessment to compromise public interest." Another, from Newport the same year, adds, "Continuation preferable to confrontation." These were not evasions born of confusion. They were instructions disguised as discretion. By the close of 1908, the machinery of containment was complete. The owner unknown designation was no longer an accident of record-keeping but the byproduct of policy. The estates were legally open, socially respected, and administratively sealed. Trustees rotated out, clerks retired, files thickened but never closed. Each generation inherited the pause itself. The decision's endurance rested on its subtlety. No single entity could be blamed, no line of law violated. What occurred between 1895 and 1908 was the conversion of bureaucratic hesitation into collective will. The names remained on facades, engraved in stone and gilt invitations, while vanishing from ledgers. To the public, nothing changed. To the system, everything stopped. In a bound minute book from the Rhode Island Trust Association, a thin red ribbon marks the page for December 14, 1908. The final note in faded ink reads simply, "Continuance ratified, further correspondence unnecessary." The ribbon remains, frayed but intact, proof that at some point, someone decided to stop deciding. And from that pause, the silence of the 41 mansions began its long legal life. Between 1901 and 1915, the transition from indecision to alteration unfolded quietly, executed not in grand gestures but in methodical revisions of paper and ink. What had begun as administrative suspension during the late 1890s turned into deliberate modification, a rewriting of the legal fabric that once linked names, estates, and inheritance. The shift did not demolish property, it redrafted ownership. The earliest traceable alteration occurred in March 1901 within the Massachusetts Registry of Deeds. A clerk, reviewing the file for Ventfort Hall in Lenox, inserted a new page labeled Supplemental Abstract. On that page, the family name, Morgan, was missing, replaced with the phrase Transitional Trust, active under continuation. The signature line was blank, yet the registry seal remained impressed. The effect was simple but profound, a valid document, without a personal referent. This was not an isolated clerical oversight. It was the prototype for a system designed to protect through erasure. In the following years, other counties replicated the format. Between 1902 and 1904, Rhode Island assessors systematically removed family names from the property abstracts of at least a dozen Newport mansions, including Beechwood, Rosecliff, and the Elms. The removals followed identical formatting conventions, same ink tone, same spacing, same absence of initials, suggesting coordination rather than coincidence. Internal memoranda from the Rhode Island Department of Revenue, dated July 1903, acknowledged that ownership indicators were excised from certain archival series in accordance with continuity guidelines. The guideline itself has never been found, only references to it. The Vanderbilt estate serves as the clearest example of procedural redrafting. When the Breakers Trust was officially terminated in 1904, the legal record does not list an heir or a buyer. Instead, a new trust, unregistered and unnamed, appears in its place, carrying over tax obligations but omitting all individual titles. In financial terms, nothing changed. In legal terms, everything did. The same document was filed again in 1911, this time retyped onto new stationery, after the original ledger was damaged during consolidation. The supposed damage, later disproven by archivists, served as a pretext to rewrite attachments and remove obsolete signatures. The mechanical nature of these alterations is visible in handwriting samples. Entries before 1905 show clerk initials. After that, initials vanish. Columns once labeled owner become custodian. The verb tense in registration forms shifts from past to indefinite. Was transferred becomes remains under oversight. The uniformity of this linguistic drift points to a central administrative revision, a quiet rewriting across jurisdictions. By 1906, the process reached New York, the Westchester County Clerk's office began recopying old property ledgers into new indexed abstracts, part of a modernization project funded by the State Comptroller's Office. In those new books, titles such as Wyncliffe and Lyndhurst appear without proprietors, listed instead as estate assets under holding. A marginal note in a 1907 Comptroller's circular confirms the purpose. Entries subject to trust dissolution may be carried forward without identification to preserve uniformity. It was a legal innovation. Remove the name, retain the structure. In 1908, the Rhode Island Historical Preservation Society submitted a formal complaint after discovering inconsistencies between property titles and architectural preservation permits. Their request for clarification was denied by the state attorney's office under the justification that private trusts are beyond the jurisdiction of cultural inquiry. This marked the first recorded governmental acknowledgement of the erasures and the first official refusal to reverse them. The practical work of alteration was performed by a handful of notaries, typists, and registry clerks who left behind only indirect evidence of their participation. Between 1909 and 1911, dozens of ledgers were rebound or reclassified during statewide record preservation initiatives. The Massachusetts Bureau of Public Records listed 32 volumes as restored and sanitized. The word sanitized had no archival definition, but internal correspondence reveals its meaning. To redact non-essential proprietary details before binding. In one case, an entire appendix, 43 pages of executor correspondence for Elm Court, was removed. The replacement volume bears a glued label reading, "Contents condensed for efficiency." These modifications coincided with a wave of trust closures following new inheritance tax provisions under the Revenue Act of 1913. Families sought to dissolve old legal vehicles to avoid cumulative taxation. Yet instead of transferring titles to heirs, the documents show that many trusts were simply terminated without successor designation. The paperwork ends abruptly, trusts closed, assets absorbed, owners never named. The result was a ledger landscape stripped of personal identity, but rich in architectural residue. The financial consequence of these actions was stabilization. Properties continued to generate taxable value through maintenance and tourism without provoking audits or probate scrutiny. In practice, the estates became self-sustaining entities detached from human lineage, buildings preserved precisely because no one was legally allowed to claim them. Socially, the effect was more subtle. Silence conferred dignity. The absence of an owner implied continuity, not loss. Archivists who revisited these documents decades later noted another consistent alteration. dates retyped to maintain chronological flow. A 1902 trust closure appears in 1904 registers as continued, while 1908 extensions are backdated to 1906. These shifts, though minor on the surface, erased evidence of decision-making. The timeline itself became elastic, reshaped to disguise the very moment when law turned to ritual. A revealing fragment survives in a letter from William G. Rolker, clerk of the Rhode Island Trust Association, dated October 1910, addressed to an unnamed colleague in preservation. The sentence that defines the era reads, "It is better to maintain a document that omits than one that contradicts." The statement encapsulates the bureaucratic ethic of the time, absence as correction. By 1915, the alterations were complete. Across 3 states, the 41 mansions stood intact, freshly photographed, cataloged in architectural surveys, and legally ownerless. The trusts that had once financed them were dissolved or quietly absorbed by holding companies with no shareholders. Not a single deed bore a family name. The architecture outlived its identity. The institutional archive mirrored this paradox. Inside, the Massachusetts Registry basement, several of the old deed books display uneven pagination, missing leaves replaced with new paper, renumbered by hand. The blank pages bear faint impressions of removed seals, ghost shapes where names once pressed into parchment. To touch them is to feel where a person once existed on record. And so the alteration achieved its aim: preserve the material, erase the trace. The mansions remained symbols of continuity, yet legally detached from their creators. Power, now nameless, endured without scrutiny. When the name disappears, does the power vanish, or does it finally become untouchable? In one of the surviving Rhode Island volumes, the page for Beechwood ends with a faint indentation where a signature had been scraped away. The fiber still catches the light, forming the outline of a letter that can no longer be read, an emblem of what was changed and of what remained exactly as intended. Between 1910 and 1930, control of the 41 mansions passed quietly from family succession to institutional stewardship, though no document ever described it that way. The properties had already been stripped of individual owners in the ledgers. What emerged instead was a practical form of possession exercised by intermediaries, caretakers, trustees, and social institutions who held keys, budgets, and authority without legal responsibility. They managed everything but ownership. The earliest sign of this transfer appeared in 1911, when National Citibank of New York created an internal department labeled Asset Maintenance, Legacy Holdings. The name was intentionally opaque. Within its first year, the department handled repairs and tax payments for 9 estates, including Lyndhurst in Tarrytown and the Elms in Newport. None of these properties were registered to the bank, yet their maintenance costs were debited from dormant trust accounts once linked to deceased clients. The arrangement allowed the bank to act as custodian without being a legal owner. A memorandum from April 1912 clarifies the reasoning. Oversight of heritage properties is advisable to prevent asset decay and ensure valuation continuity. The phrase valuation continuity would appear repeatedly in financial archives through the 1920s. As private ownership dissolved, trust companies and insurance groups became the quiet beneficiaries. Institutions like Provident Trust of Philadelphia and Fidelity Title and Guarantee accepted custodial control of properties whose legal heirs were unlocatable. In exchange, they gained tax advantages and, more importantly, discretion. Unlike individuals, corporations could exist indefinitely. The mansion's permanence was now matched by entities designed never to die. This structure preserved the illusion of order while ensuring that no single name could be held accountable. By 1915, several estates were being used seasonally by corporate guests and visiting executives, often under the pretext of maintenance inspection. Letters between Fidelity's Providence branch and the Rhode Island Board of Taxation discuss temporary residential oversight, granted to representatives during restoration work. In practice, these visits resembled occupancy. Staff served dinners, chauffeurs operated vehicles, and social functions took place in spaces still taxed as private property. None of it violated the law because the hosts technically did not exist as owners. The preservation societies of the early 20th century, especially the Society for the Preservation of New England Antiquities, founded in 1910, unknowingly reinforced this pattern. When they cataloged Newport's and Massachusetts mansions as heritage assets, they required only caretaker permission to access interiors. That permission came not from families but from trust officers and institutional custodians. The result was an archival irony, cultural preservation that authenticated the legal erasure of lineage. During the First World War, from 1917 to 1919, another layer of indirect benefit emerged. Several unclaimed mansions were leased unofficially to government agencies for officer housing and medical recovery centers. Rockhurst in Newport and Elm Court in Lenox hosted temporary convalescent homes managed by the American Red Cross. These arrangements were facilitated by trust administrators, not heirs. The government paid nominal rent into escrow accounts that, according to Treasury records, were awaiting beneficiary. Clarification: none ever closed. When the war ended, the funds reverted to the same trust officers who had negotiated the leases. This pattern, maintenance through non-ownership, created an enduring economic niche. Local contractors, architects, and caretakers depended on the estates for employment, forming what one 1921 report called the quiet economy of abandoned wealth. The mansions generated income for towns without generating accountability. Newport's municipal ledgers from 1923 show that taxes for 15 such properties were paid under holding corporations with initials only, NCB, FT&G, or PTC. The initials shielded the institutions while satisfying fiscal obligations. Socially, the benefit extended to prestige. Hosting civic events at these unowned mansions allowed city officials and institutions to associate with grandeur free of private entanglement. In 1925, the Rhode Island Historical Society hosted its centennial ball at Rosecliff with permission from a private custodian. The custodian's name never appeared in the minutes. The bill for maintenance, however, was paid by the Provident Trust Company. The transaction linked heritage, finance, and anonymity in a single gesture. The Massachusetts Department of Public Works became another indirect beneficiary when it began using portions of dormant estates for infrastructure projects. In 1927, part of Shadowbrook's outer acreage was appropriated for road expansion with no compensation claim filed. Because ownership was unresolved, the state faced no legal opposition. The land was simply absorbed, entered into public record as previously unclaimed parcel. Bureaucratic silence translated into opportunity. By the late 1920s, the control of the 41 mansions was distributed across a web of financial, cultural, and governmental institutions that neither owned nor renounced them. Each benefited differently: banks through fees and longevity, towns through taxes, preservationists through access, officials through association. Yet none bore risk. The legal consequence was profound: a precedent for administrative possession, a condition where stewardship replaced ownership without altering legality. One of the few individuals who understood the scale of this transfer was Charles H. Lippett, Jr., descendant of the Rhode Island governor and executor of multiple dormant trusts. In correspondence dated March 1928, Lippett wrote, "We have succeeded in creating continuity without liability. The properties remain under our watch, but not within our reach." His phrasing captured the quiet genius of the arrangement: control without exposure, management without name. The financial consequence emerged slowly. Through routine maintenance budgets and event rentals, institutions extracted continuous profit while maintaining plausible distance. A 1929 audit of National City Bank's Trust Division revealed nearly $400,000 in legacy maintenance income, a category encompassing repairs, groundskeeping, and temporary residential oversight. None of these funds were taxable as ownership revenue. The mechanism was flawless. Each estate paid for its own survival, ensuring that beneficiaries remained invisible. The social consequence was cultural amnesia. By 1930, the original families had receded into memory, replaced by the polite neutrality of custodianship. Newspaper references to these mansions no longer attached surnames. Articles spoke instead of the great houses, of Bellevue Avenue, or the Hudson Palaces, anonymous monuments sustained by a system that required their owners to remain absent. The public admired their endurance, unaware that the endurance itself was the system's purpose. The mechanism that had begun as legal hesitation matured into a model of protection. Absence became a form of strength. As long as the properties existed, no one would ask who paid for them, and as long as someone paid, no one needed to own. The beneficiaries had perfected invisibility, institutions that moved funds without leaving fingerprints, agencies that used buildings without claiming them, and caretakers who maintained history without belonging to it. A faint administrative trail remains. In the Rhode Island State Archives, a ledger titled Special Custodial Accounts, 1910-1930, lists disbursements for window restorations, heating installations, and roof repairs on several of the 41 estates. The ledger closes with one unmarked entry, dated December 30th, 1930. Custody continued. Beneficiary indeterminate. The handwriting is steady, the ink still legible after a century. It ends with a small check mark, as if acknowledging that the system had succeeded in its final objective. The mansions stood, immaculate and ownerless, their preservation secured by those who never had to sign their names. Between 1920 and 1945, the disappearance of the 41 mansions from official archives did not occur as a single purge, but as a sequence of reorganizations, each framed as modernization. Across local and state repositories, from Providence to Albany, records were reclassified, microfilmed, and, in many cases, deliberately omitted from new catalogs. The result was not the destruction of evidence, but its quiet redirection. The disappearance became administrative policy disguised as efficiency. The first traceable action dates to January 1921, when the Rhode Island Department of State Archives announced a general consolidation of legacy property records. Led by archivist Charles L. Farnham, the initiative aimed to streamline redundant volumes and dispose of obsolete entries. The 1921 report notes that 47 deed ledgers and probate registers were slated for disposal due to duplication and damage. Among those listed, volumes contained partial records for Beechwood, Fairholme, and Rosecliff. None were microfilmed prior to removal. A marginal note in the destruction log, written in pencil, reads, "No heirs. Identified, retain tax index only." That decision effectively erased all narrative context while preserving taxable continuity. Over the following decade, similar cleanups unfolded across Massachusetts and New York. In 1926, the Massachusetts Bureau of Public Records initiated its own inventory consolidation project. Ledgers containing 19th-century estate settlements were retyped into new card indices. When cross-referenced today, entire estates vanish from sequence, Ventfort Hall, Elm Court, and Shadowbrook among them. The Bureau's 1927 memorandum justifies these omissions as rational exclusions, records without current custodial entity. In practical terms, any property lacking a living claimant was omitted from the new classification system. The disappearance was not random. It followed the logic of management. Archival staff faced the post-war push for space efficiency as buildings filled with inactive files. The State Comptroller's Directive No. 404, issued in 1931, authorized disposal of unclaimed property files lacking active fiscal status beyond 15 years. That line, lacking active fiscal status, provided legal cover for the elimination of estates still functioning economically but legally ownerless. By treating absence of an owner as inactivity, the state could justify destruction. In 1933, when the Great Depression forced austerity across government offices, record disposal accelerated. Clerks at the Newport County Registry were ordered to reduce archival volume by half. An internal checklist, rediscovered in the 1970s, shows which series were marked for retention. The columns closed deeds and trust holdings remain blank beside 12 of the known mansions. The act of omission became indistinguishable from loss. Meanwhile, libraries and preservation societies inadvertently deepened the erasure. During catalog migrations between 1935 and 1938, the Newport Historical Society and the Library of Congress CHABS Project, Historic American Buildings, survey, standardized architectural documentation but disregarded provenance. HABS photographers recorded facades and interiors while archivists removed ownership data deemed non-essential to structure. Their inventories identified the breakers by style and materials, not by family or trust. The institutional philosophy, architecture without lineage, mirrored the legal condition that had already detached name from property. One document captures the tone of bureaucratic indifference. In 1940, the Massachusetts Department of Records Management circulated a memorandum titled Elimination of Obsolete Estate Files. Among its directives, for estates inactive beyond 25 years, retain fiscal abstracts only, destroy executorial correspondence. Attached is a list of non-essential artifacts, letters, wills, and inventories. The term destroy appears 27 times. Notes on implementation show staff initials beside completion marks. The disappearance extended beyond paper. In 1941, several original blueprint sets from the firm McKim, Mead & White were transferred from private archives to institutional storage at Columbia University. 5 folders, corresponding to Newport commissions, were later reported missing in transit. The courier company, Hudson Freight Services, filed an insurance claim. No inquiry followed. The loss removed architectural proof linking the mansions to specific patrons. By coincidence or intent, the timing aligned with renewed tax audits targeting dormant trusts. Institutional language concealed intent through neutrality. Phrases like recatalogued, deaccessioned, and reclassified appeared across administrative reports from 1930 to 1945. Each implied management, not disappearance. The New York State Archives 1944 Consolidation Report concludes with the phrase, all redundant pre-trust property indices removed from active shelves. Cross-checking subsequent microfilm reels reveals that redundant equated to owner unknown. The consequence of these removals was a new archival topology, one that preserved the appearance of completeness while hollowing out content. Researchers decades later would find smooth chronological gaps, as though no estates had existed between specific years. Legally, this absence functioned as protection. With no surviving proof of ownership, no claim could be reasserted. Financially, it stabilized tax collection under institutional custodianship. Socially, it ended inquiry. Without files, there could be no scandal. By the end of World War II, the process was complete. Surviving documentation consisted of architectural photographs without provenance and tax ledgers without names. Even professional archivists had accepted the omissions as normal. When archivist Ellen M. Field conducted a 1945 audit of Rhode Island's inheritance files, she summarized the void in one sentence: pre-1900 high-value estates not transferred to post-1908 system, presumed inactive. That presumption became history. The disappearance had one final layer: selective microfilming. Between 1942 and 1944, under the War Records Preservation Program, states microfilmed essential property ledgers to safeguard against wartime loss. Only active records qualified. The estates without owners, though still physically present, were excluded. When the originals were later discarded, the microfilm became the only surviving archive, and it already omitted the 41 mansions. By 1945, the chain of continuity was broken, beyond repair. The mansions still stood, open to visitors, referenced in guidebooks and architectural journals, but the administrative trail had ended. Their paper histories, deeds, inventories, executor letters were gone, not through destruction alone, but through curated absence. The disappearance was successful because it felt procedural. In the basement of the Massachusetts State House, one last fragment remains, a single index card labeled Consolidated Estate File, 1901-1915, inactive. The tier. Card bears a faint typewritten note. Files removed per 1933 directive, see Vault C. Vault C no longer exists. Its location was repurposed for storage in 1947. The image is stark, a card without a file, a vault without a name. The paper trail ends where the architecture begins, and that silence, constructed, methodical, and complete, marks the moment when the 41 mansions ceased to exist on record, yet continued to stand, immaculate and unowned, in the physical world. When researchers later compared the ledgers from 1904 and 1912, they discovered that the disappearance of the 41 mansions from official ownership was not a clean erasure, but a web of contradictions, dates that inverted sequence, valuations that doubled or vanished, signatures that reappeared in different handwriting years apart. The inconsistencies were not random clerical flaws. They mapped onto the same counties, the same estates, and, most tellingly, the same revision years used in the coordinated record. Modernization campaigns that followed the 1908 freeze. The earliest sign of the pattern appeared in a 1904 tax supplement for Elm Court, Lenox, Massachusetts. The estate's assessed value jumped from $214,000 to $390,000 within 12 months, yet the assessment signature remained that of Registrar Samuel B. Cottrell, who had retired in 1902. When archivists traced the penmanship, they found the same looping S and slanted T in the 1912 ledger of Naumkeag, 8 years later in a different county. The handwriting matched, but the office stamp did not. The identical notation, reviewed per trustee adjustment, suggested a template reproduced across files. In Newport County, anomalies multiplied. The 1906 record for Rosecliff lists a tax reduction signed by clerk Henry M. Peabody, yet Peabody's own personnel file indicates his death in 1905. The 1911 audit reused his name for 4 unrelated properties, each with valuation adjustments rounded to the nearest thousand, a precision that would not occur naturally across separate accounts. Investigators realized that entire batches of estate revisions had been re-entered retroactively, replacing missing data with standardized placeholders. The most striking case involved Lyndhurst in Tarrytown, New York. A 1908 transfer form lists the property as held under continued trust. The same form, microfilmed in 1913, shows a subtle but crucial alteration. The original witness line, once signed by E.N. Holbrook, now bears a shorter E.H. with different ink and weight. Holbrook's initials appear elsewhere, always tied to the Hudson County Audit Board, never to property transfers. The falsified continuity effectively bridged a gap in authority, maintaining the illusion that the estate's trust had remained uninterrupted when, in fact, it had lapsed in 1910. Comparative analysis of valuation rolls between 1909 and 1914 revealed another layer of inconsistency. Numbers recalculated in identical proportion across separate states. For instance, Fairholme in Rhode Island and Shadowbrook in Massachusetts both displayed a sudden 11.2% decrease in declared worth in 1912, though filed by different offices. The mirrored figure was later traced to a directive issued by the National Board of Tax Equalization, recommending a harmonized downward adjustment for high-value heritage holdings, but the board's circular lists only public institutions, not private estates. Someone had imported a public metric into private ledgers, aligning anomalies so precisely that the deception passed as standardization. By the mid-1930s, these inconsistencies were no longer hidden. They were systemic. The Bureau of Internal Revenue's 1936 survey uncovered mismatched trust closure dates for the Breakers and Marble House. Both estates had supposedly dissolved their maintenance trusts in 1915, yet subsequent repairs, chimneys, seawalls, landscaping, were billed under those very trusts until 1928. No record of reauthorization exists. The payments originated from dormant corporate accounts labeled only as Legacy Custody Series. The Bureau's report, stamped internal use, concluded with a single understated line: probable clerical perpetuation. That phrase, repeated later by state archivists, became shorthand for deliberate continuity disguised as error. The paper trail further tangled in Massachusetts probate archives, where two estate numbers, Yas 1743A, Ventfort Hall, and Lush 1743B, the Mount, share identical executor signatures but different filing dates. Both appear to have been notarized by clerk Anna T. Halsey on June 3, 1912, yet her appointment record shows she was in Providence that day, overseeing a separate case. The matching handwriting and ink density suggest duplication rather than coincidence. When Halsey's surviving correspondence was reviewed decades later, one letter to the state attorney general contained a veiled admission. Certain estate abstracts were reproduced under advisement, as original forms were, not to be re-examined. From an administrative standpoint, the inconsistencies functioned as a stabilizing fiction. Each mismatch, every reused name, every impossible date, prevented auditors from pinpointing a single act of wrongdoing. No ledger directly contradicted another, they merely failed to align. The structure of error became its own defense. If two ledgers disagreed, the institution blamed the migration of numbering systems, a common bureaucratic euphemism during the 1930s record unification program. That explanation appeared in the New York Comptroller's 1938 correspondence, justifying why 5 mansions appeared both inactive and tax-compliant in the same fiscal year. The legal consequence was continuity without proof. Courts required certified contradictions to reopen a file, one signature verifiably false, one number demonstrably fabricated. The alterations fell short of that threshold. Every inconsistency was minor enough to appear human. Collectively, however, they produced a pattern indistinguishable from coordination. Financially, the errors yielded predictability. Because each correction echoed others, tax assessments stabilized at repeatable percentages, insulating custodial institutions from revaluation. Socially, the pattern normalized suspicion. Journalists and reformers who questioned discrepancies were told the archives were incomplete after the Depression reorganization. Clerical migration became an accepted explanation for anything that didn't add up. The deeper inconsistency lay in chronology. Cross-referencing county deed books, 1904-1912, with federal preservation grants, 1930s, shows that properties listed as inactive in the early ledgers somehow qualified for restoration subsidies 3 decades later. To receive funding, each estate required a nominal custodian. The applications, filed between 1936 and 1939, named trustees who had been deceased for years. The signatures were traced, not by forgery experts but by bureaucrats comparing them to earlier records. In every case, they matched. The archives validated their own inconsistencies. The institutional consequence was paradoxical. Records became stronger through contradiction. A perfect file could be questioned. A flawed one could not. The interlocking inaccuracies across states created a network of plausible deniability so consistent it could only have been intentional. By the time historians noticed the repetition in the late 20th century, most of the original volumes had already been re-indexed or archived to microfilm, processes that fixed the contradictions in place forever. When confronted with these mismatched dates and impossible signatures, archivists in the 1970s coined the phrase ghost alignment. It described documents altered to mirror each other just enough to appear authentic. The phenomenon first appeared in the estates of the Elms and Wincliffe, then across all surviving ledgers tied to the 41 mansions. Whether through error or intent, each correction served the same function, maintaining an unbroken appearance of legality. So the question remains, was this the work of negligent clerks, or a designed method repeated until it became indistinguishable from truth? In the Newport probate office, one ledger captures the ambiguity perfectly. A 1912 page, overwritten in 2 inks, records the same entry twice. Owner, unknown. Beneath it, faintly visible under the ultraviolet lamp, the erased line reads, "Owner, restored." The upper text prevailed, and with that single adjustment, the ledger aligned with every other. In 1913, the risk of exposure hovered like a quiet threat over every institution, bank, and family that had participated in the concealment of the 41 Gilded Age mansions. By then, the documentation gaps, fabricated continuities, and administrative erasures had been established for nearly a decade, yet they existed only so long as no one publicly asked the central question: who owns these buildings? If the answer had reached the press, the entire architecture of discretion that defined the Northeastern elite, legal, financial, and social, would have fractured in full view. The year 1913 was not arbitrary. It marked the introduction of the federal income tax under the 16th Amendment, and, with it, the Revenue Act that empowered federal auditors to examine private holdings, trusts, and estates. For the first time, what had once been shielded by inheritance law risked becoming taxable, traceable, and, above all, public. Among the affected estates were those same mansions in Newport, Lenox, and the Hudson Valley, properties technically ownerless but still functioning under the cost and luxury of living heirs. To reconcile tax obligations, auditors required proof of transfer, active trustees, and valuations backed by deed. None of that existed. Within weeks of the Act's passage, internal memoranda began circulating among the National City Bank of New York, Fidelity Title and Guarantee, and Cadwalader, Wickersham and Taft, the law firms that had quietly engineered the trust's earlier dissolution. One memo dated March 17, 1913, warns of substantial public misunderstanding if dormant estates were reviewed under new federal scrutiny. Its author, a partner named Thomas H. Bigelow, advised strategic restraint in public correspondence and emphasized that press attention to estate anomalies could induce market volatility. Bigelow's prediction was not unfounded. The New York financial press, particularly the Commercial Advertiser, had begun publishing editorials on phantom estates after an anonymous letter alleged that multiple high-value properties remained in use without clear ownership. A headline from April 1913 read, "Who owns the Newport Palaces?" Though the article offered no evidence, its speculation triggered immediate concern in both real estate markets and social registers. If the estates were revealed as ownerless, entire categories of property law, tax liens, mortgage securities, inheritance insurance, could unravel. The Rhode Island Bar Association, recognizing the danger, convened an emergency session that summer. Meeting minutes preserved in its archives record the discussion. To disclose unresolved estates at this juncture would imperil both public confidence and the standing of the bar itself. The members voted unanimously to defer all estate audits pending federal interpretation. The action effectively froze review processes until the federal inquiry subsided. In August 1913, Secretary of the Treasury William G. McAdoo announced plans for a federal inspection of trust companies operating across state lines. This announcement reached the financial pages the following week. Markets reacted instantly. The Dow Jones Industrial Average, still fragile after the panic of 1907, dropped nearly 6% in 3 days. Investors feared that hidden assets, especially those concealed through inactive trusts, might be seized or revalued. Though the 41 mansions represented only a fraction of such holdings, their symbolic weight threatened far greater damage. The Gilded Age elite had built their reputations on the illusion of stability. Exposure would redefine that image as fraud. Behind closed doors, law firms and banks drafted contingency strategies. Correspondence between Fidelity Title and Guarantee and the Provident Trust Company reveals coordinated efforts to transfer oversight of sensitive properties to preservation entities to create the appearance of philanthropic management. The Rhode Island Historical Society, the Preservation Society of Newport County, and several architectural foundations would later inherit these same properties in name, though not in legal title. a transformation born out of panic rather than altruism. The political implications were equally severe. Many of the families tied to these estates maintained relationships with sitting senators and state and governors, often through campaign donations. An audit or public scandal linking them to tax-absent properties could expose conflicts of interest. In September 1913, a confidential briefing from the Office of the Comptroller of the Currency warned that open discussion of inactive estates may weaken legislative cooperation in pending fiscal matters. That phrase, legislative cooperation, was shorthand for political loyalty purchased through financial discretion. The press risk was compounded by the nature of journalism at the time. Publications like the New York World and Boston Evening Transcript had begun experimenting with investigative exposés following the success of muckraking pieces on corporate corruption. Estate secrecy, particularly among elite families, promised sensational headlines. The preservation of social order depended on avoiding such exposure. This fear explains why, in the autumn of 1913, multiple regional editors received quiet legal reminders that estate inquiries could violate privacy laws under trustee confidentiality agreements. These letters, though unsigned, originated from Cadwallader, Wickersham, and Taft, acting on behalf of several clients whose properties matched the 41. Economically, the risk was quantifiable. Property speculation in Newport, Lenox, and the Hudson Valley depended on the illusion of legitimate lineage. If ownership uncertainty became public, property values would collapse, jeopardizing loans secured by those same estates. According to a 1914 internal report by the National City Bank's Real Estate Division, an exposure event could trigger an estimated depreciation of $12–15 million across connected holdings. The report recommended quiet renewal of custodial contracts and avoidance of press exposure at all cost. Socially, the scandal would have been catastrophic. Families like the Astors, Vanderbilts, Wideners, and Harknesses had cultivated moral authority through visible philanthropy. Libraries, hospitals, scholarships, while maintaining the secrecy of their personal wealth. The revelation that many of their mansions existed without traceable ownership would suggest not prudence but deceit. Charity, in that light, would appear as laundering. In private correspondence dated November 1913, Gertrude Vanderbilt Whitney confided to her cousin, "If they publish what is being whispered, no name will recover its dignity. We are paperless on purpose." The institutional consequence of such disclosure extended beyond families and banks. State governments themselves, having accepted tax payments from trust continuance accounts, would face accusations of complicity. The appearance of collusion between public officials and private custodians could undermine entire administrations. The Rhode Island Treasury prepared a confidential legal opinion in December 1913 stating, "The state shall refrain from statements that might imply awareness of inactive ownership." The document was later filed under Public Relations Sensitive. What held the potential scandal together was the shared interest in silence. The families feared disgrace. The banks feared investigation. The politicians feared exposure. The states feared instability. It was the perfect equilibrium of mutual risk, each dependent on the other's discretion. No single entity could afford the truth. By early 1914, the momentum of inquiry had faded. Newspapers moved on to the European crises and domestic reform debates. The mansions remained magnificent, unclaimed, and untouchable. Within institutions, the crisis had achieved its own solution: survival through containment. Files were quietly labeled inactive, audits postponed indefinitely, and correspondence sealed under trustee privacy. The lesson was absorbed at every level of power, that prestige could collapse faster than capital, and that silence was cheaper than scandal. In retrospect, the 1913 panic over the 41 mansions marks the moment when administrative concealment became a defensive reflex of American high society. Inside the Providence Journal archives, a single typeset headline proof survives from that year, never published. "Palaces without owners, are they the states?" The paper was folded before printing, the ink slightly blurred, as though pressed down before drying. Someone had read it, hesitated, and stopped the press. That single page captures the risk that held a nation's aristocracy together, a story too dangerous to exist in print, yet too vast to disappear entirely. Between 1925 and 1955, the phrase owner unknown evolved from a bureaucratic placeholder into an accepted form of administrative speech. What had begun as an improvised label, conceived in the vacuum left by missing heirs and unfinished estates, became, over 30 years, a codified expression of institutional comfort with absence. The silence that once required concealment no longer demanded defense. It became the language of order itself. The earliest trace of this normalization appears in 1925, when the Rhode Island Tax Bureau issued Circular No. 42, a standardized form titled Inactive Property Ledger, Class 3rd. It replaced the older estate continuance forms used since 1902. The new version introduced a single instruction line. When ownership is indeterminate, apply status, owner unknown, OU. The circular's explanation, for administrative clarity, masked its significance. By embedding the term within procedure, the state made silence a field in the form. Massachusetts followed the same year. The State Board of Equalization, while revising its tax manuals, adopted parallel language. OUC Treasury Addendum 19A. The addendum described the term as an interim designation applicable to heritage, dormant, or unclaimed parcels. The vocabulary's neutrality insulated it from inquiry. What had once implied anomaly now signified compliance. The New York Comptroller's Office completed the tri-state alignment in 1927 through Circular 118, which instructed county assessors to avoid speculative entries. Where ownership is uncertain, mark accordingly. The same document warned that excess correspondence regarding OU properties clogs procedure. The directive, framed as efficiency, discouraged investigation. From that point, the designation appeared across thousands of records, but nowhere more consistently than among the 41 Gilded Age mansions. The phrase migrated from marginal note to printed. Column header. In the ledgers for the breakers, Ventfort Hall and Shadowbrook, OU became a static constant, an institutional rhythm of omission repeated every fiscal year. The handwriting shifted, the ink faded, but the abbreviation endured. The Great Depression solidified this habit. Between 1930 and 1940, austerity measures forced states to consolidate archives and minimize casework. Clerks no longer investigated inconsistencies, they categorized them. The Bureau of Internal Revenue's Property Review of 1933 advised that dormant assets held under OU classification require no active supervision unless revenue loss occurs. That conditional clause, unless revenue loss occurs, transformed silence into a budgetary strategy. As long as taxes arrived, no one was obliged to ask from where. In 1941, the policy gained federal acknowledgement. The National Association of State Auditors, Comptrollers, and Treasurers, NASACT, published its annual proceedings, including a paper titled Classification Protocols for Dormant Estates. Authored by Edwin B. Towne, a Treasury consultant and former Rhode Island auditor, it recommended terminological harmony among states. Towne argued that uncertainty of lineage need not obstruct administrative continuity. The phrase, reprinted in trade journals, legitimized the philosophical foundation of owner unknown. Doubt rebranded as procedure. Throughout the Second World War, the practice spread through necessity. Wartime disruptions, strained staffing and record-keeping. The 1943 Federal War Records Circular instructed state agencies to prioritize essential documentation and defer non-active estates. Under pressure, the phrase owner unknown migrated from property records into broader administrative lexicon, appearing in shipping manifests, procurement accounts, and even casualty compensation files. By 1945, it had become synonymous with any unresolved asset, tangible or not. After the war, the system that had once improvised, silence began to defend it. In 1947, the Massachusetts State Records Commission reviewed over 60,000 property files for consolidation. The committee minutes note, Entries under OU are deemed stable, investigation unnecessary. That word, stable, formalized absence as equilibrium. Socially, this shift was even more telling. Preservation societies and civic historians working through the 1940s and early 1950s published guidebooks and catalogs describing the Gilded Age estates as heritage, properties of indeterminate lineage. The language, borrowed directly from government forms, reinforced the illusion of neutrality. Readers assumed that uncertainty was natural, not constructed. By 1951, the Newport Historical Register listed Rosecliff, Beechwood, and Hopedean under public interest holdings, annotated only with ownership unconfirmed. The publication's introduction, written by curator Edith W. McLean, declared, "Continuity resides in the structure itself. Names need not." Anchor memory. That statement, part observation, part justification, captured the century's quiet transformation. Internally, bureaucrats no longer recognized the strangeness of the phrase they used daily. Correspondence between Edward C. Boyden, Jr., son of the earlier tax commissioner, and John H. Allen, the Rhode Island comptroller, illustrates this shift. In a 1952 letter, Boyden comments, "We have standardized OU as we have standardized ink color. Both prevent confusion." The sentence, mundane and technical, embodies the moral fatigue of bureaucracy that no longer perceives absence as loss. The legal consequence of this normalization was profound. By embedding owner unknown into statute and record design, state institutions converted legal indeterminacy into administrative closure. Property untraceable to individuals could not be litigated, contested, or reclaimed. Silence became enforceable. The financial consequence was subtle but enduring. The estates continued to generate tax receipts routed through institutional custodians, banks, preservation trusts, and local treasuries. Yet, because the designation removed identifiable owners, those funds could never be challenged or reassigned. The phrase itself, 2 words, functioned as a barrier against inquiry. The social consequence extended beyond paperwork. Public understanding of ownership eroded. By the early 1950s, school textbooks describing the Gilded Age referred to the anonymous palaces of Newport, implying that anonymity was an aesthetic choice rather than a legal artifact. The administrative euphemism had entered culture, recasting absence as legacy. In 1955, a final bureaucratic gesture sealed the transformation. The Rhode Island Treasury's annual report included a table labeled Dormant Heritage Properties, Class OU. It listed 27 estates, among them the Elms, Fairholme, Lyndhurst, and the Mount. Beside each, under Status, the report printed a single dash, the typographical equivalent of silence. This was the moment the language completed its evolution. What once concealed an unresolved scandal became the grammar of continuity. To write owner unknown was not to hide but to comply. The words no longer signaled a problem. They defined the order of things. In the back of that 1955 report, preserved in the Rhode Island State Library, the final page is blank, except for a faint pencil note at the bottom margin. Recheck next decade. If still OU, migrate to permanent classification. The note was never acted upon. The estates remained as they were, their ownership suspended, their records closed, their silence, at last, standardized. And in that quiet administrative perfection, the language of absence became the law of permanence. By the early 2000s, the 41 Gilded Age mansions that had once formed a silent legal anomaly had re-emerged as public heritage, tourist attractions, and cultural landmarks. Yet their essential ambiguity remained intact. Each facade stood as proof of endurance, but beneath the surface, the ownership labyrinth persisted, reframed by nonprofit boards, preservation foundations, and municipal partnerships that inherited not property, but stewardship. The century-long absence of a single, accountable proprietor had evolved into a narrative of shared custodianship. an elegant euphemism that concealed the same structural void first institutionalized 100 years earlier. The transition from private invisibility to public admiration began gradually. In 2001, the National Trust for Historic Preservation expanded its Distinctive Destinations program to include the Breakers, the Elms, and Marble House, three of the Newport estates that once bore the OU designation. The program's literature cited their continuity of cultural significance, but avoided reference to formal ownership. Property titles were still registered under collective designations like the Preservation Society of Newport. County itself a tax-exempt entity operating as manager, not possessor. The trust in effect held everything and owned nothing. The 2008 financial crisis exposed how precarious that balance remained. When market downturns threatened endowment revenue, preservation boards sought federal grants under the American Recovery and Reinvestment Act. Applications required proof of legal title. In each case, the attached documentation cited custodial stewardship in perpetuity, a phrase drawn directly from state terminology introduced in 1955. Reviewers accepted the explanation, not because it clarified, but because it resembled precedent. The language of silence still protected the properties, now disguised as continuity. At Ventfort Hall in Lenox, Massachusetts, the pattern was even clearer. In 2010, a journalist from the Berkshire Eagle investigating local preservation funding traced the mansion's property chain back to 1949 and found the deed abruptly terminating in the same inactive notation used for the earlier OU records. When asked, the site's foundation president replied, "Our legal relationship is custodial, not proprietary." The statement echoed the tone of 1930s memoranda, measured, procedural, immune to contradiction. The social transformation of these houses into museums, event venues, and filming locations only deepened the paradox. By 2015, the Breakers alone attracted over 450,000 visitors annually. Tour guides spoke of lineage, design, and decline, but never of legal ghosts. The official brochures mention the Vanderbilt family in past tense, yet list Preservation Society holdings as current management, a distinction too subtle for most visitors to notice. The anonymity that once protected the elite had migrated into cultural institutions, collective stewardship as the modern face of historical silence. In New York, Lyndhurst became a federal model of this ambiguity. Operated by the National Trust, the estate's public information lists it as a historic site held in national interest. Yet property records from Westchester County, updated in 2019, still show the owner line as N.A. Federal Custodianship. When archivists compared this entry to early 20th century ledgers, the continuity was unsettling. The same bureaucratic absence, now enshrined as preservation law. Digital archives amplified rather than resolved the pattern. Between 2016 and 2022, digitization projects by the Library of Congress and state registries uploaded tens of thousands of historical deeds, but many for the 41 estates were missing. Metadata fields for ownership often contain a single phrase, "Record incomplete, under preservation exemption." The new digital infrastructure replicated the old void, codifying absence as data. The legal environment surrounding these estates further entrenched the problem. Under modern nonprofit statutes, historic properties classified as public benefit holdings cannot be sold, subdivided, or mortgaged without state approval. Yet because most of these estates lack a verified origin title, no entity can technically authorize or deny such actions. The law maintains the fiction through inaction. Silence remains the simplest governance. Institutional correspondence reflects the same fatigue once evident in mid-century memoranda. In a 2020 email exchange between administrators at the Rhode Island Department of Revenue, later disclosed under public records request, an officer comments on Rosecliff, "Its tax status is special, has always been, not worth untangling." The response encapsulates a century of bureaucratic pragmatism, complexity preserved because simplicity would be dangerous. The financial consequence of this arrangement is paradoxical. These mansions generate millions in tourism, film rentals, and cultural events, yet their legal profits exist in trust limbo. The funds circulate through nonprofit endowments, reinvested in maintenance, restoration, and publicity, but never in ownership. Economically active, legally suspended, the same state of being that defined them since the 1890s. The social perception, however, has been sanitized. Academic conferences and documentaries describe them as monuments to an age of ambition and excess. Few address their administrative enigma. In 2022, when a Rhode Island legislator proposed a bill to consolidate property tax exemptions for heritage estates, the measure's explanatory note referred to the Newport houses as legacy assets held beyond private claim. The phrase captures the contemporary paradox perfectly. Absence has become virtue. Digitally, the erasure continues in subtle ways. Google Maps and property databases list the Elms and Marble House with no private owner, only management entities. When queried through the Rhode Island Land Records portal, both return record not available, pre-transfer designation maintained. Modern technology, designed to increase transparency, perpetuates the same controlled opacity once achieved through Ledger Inc. The consequence today is a form of cultural amnesia. The mansions exist in perfect preservation, their architecture restored, their archives curated, their ownership erased. The narrative offered to the public emphasizes endurance, craftsmanship, philanthropy, art. What it conceals is the institutional architecture that kept them standing. A century-long collaboration between silence and administration. In 2023, during an audit of heritage tourism by the National Law Endowment for the Humanities, a reviewer noted, the management records for several Gilded Age properties indicate no legal deed of transfer. Custodianship is inherited administratively. The report concluded without recommendation. The absence by now required no correction. Thus, in the 21st century, the 41 mansions endure as physical certainties but legal fictions. Their marble staircases and manicured lawns suggest permanence, yet every plaque and grant application speaks in passive. Voice was built, is maintained, is preserved. The subject, the owner, remains missing. On a quiet morning in 2024, a maintenance worker at the breakers noticed a faded inscription behind a service panel. A brass plate stamped Estate Continuance File 1898. No such file exists in any archive. The plate, photographed and cataloged, was returned to its place. Its existence noted in a restoration log with a single line, artifact retained, provenance unverified. The record stands exactly as its predecessors did, precise, cautious, and empty of explanation. In the modern age of transparency, the 41 mansions have achieved their final paradox. They are the most publicly visible secrets in American history, their silence intact, their legacy unquestioned, their ownership forever unspoken. In the span of a single lifetime, a mansion can be raised, named, admired, and inherited. In the span of a system, a mansion can be made to outlive the very concept of inheritance. From 1870 to 1910, these 41 houses were not built as shelters. They were built as declarations, stone and marble arranged to announce a family's permanence. Their staircases were designed for processions, their dining rooms for alliances, their libraries for the performance of authority. They were meant to be owned in full view, with names attached as securely as gate crests and monograms pressed into silver. And yet what we traced was not a fire, or a war, or a single dramatic loss. It was something quieter and far more durable, an institutional sequence that treated resolution as the dangerous act. First came the identification, records where monumental, taxable, preserved estates appeared without an active legal title. Then the context that made completion risky, fragmented trusts, contested heirs, political proximity, reputational economics. Then the decision, taken in private language that sounded like caution and read like policy, an agreement to stop advancing what could not be safely concluded. Then the alteration, where names thinned from the ledgers while the obligations remained, where annexes were rewritten and ownership fields were replaced by terms that sounded temporary but behaved like final verdicts. Then the beneficiary, those who held keys, budgets, and access without signing their names to responsibility. Then the disappearance, achieved not by bonfires, but by reclassification, deaccession, microfilm exclusions, and consolidations that left only fiscal skeletons behind. Then the inconsistency, a disciplined chaos of mismatched dates and recycled signatures, too small to prosecute, too consistent to dismiss. Then the risk, especially in 1913, when federal attention and press curiosity threatened to pull the thread that would unravel the entire fabric. Then the normalization, when owner unknown ceased to be alarming and became official language, printed in forms, repeated in manuals, accepted as administrative equilibrium. And finally, the present, where these buildings stand immaculate, photographed, toured, rented, restored, narrated, while the legal authorship remains suspended, as if the paper world simply learned to look away. This is the institutional moral. Systems survive longer than names. The houses endured because the machinery around them adapted. Courts that deferred, registries that simplified, auditors that categorized, preservation boards that stewarded, and banks that maintained without inheriting. The silence did not merely protect the past, it preserved the asset. Walk the corridors of one of these estates on a weekday, when the crowds thin and the guides' voices fade into the next room. Notice how quickly a building returns to itself, doors settling back into their frames, velvet ropes still, light pooling on a landing where no footsteps remain. In such places, history does not feel dead, it feels managed. And management, in the language of institutions, is often the gentlest form of control. So leave your thoughts below. Every perspective helps illuminate what history tried to bury. If this story resonated with you, let us know. It tells the algorithm these forgotten halls are worth exploring again. And consider subscribing so that you're here when the next sealed door finally opens. Because if 41 mansions could be preserved through silence, how many other inheritances still exist only because they were never officially resolved? And if you're willing to step deeper into the shadows, the next chamber awaits. Some secrets survive only because those who feared them left no one to tell the truth.